One of the most important roles a lawyer plays is that of a problem solver. Most people do not even think about seeking or needing a lawyer unless they have a problem and think an attorney might be able to help them resolve it. The Iowa State Bar Association has put this video together to provide you with information about alternative ways to resolve your problem or issue. It is not an attempt to provide legal advice. And in fact, the Iowa State Bar Association would encourage you to consult with your attorney regarding your legal issue so that you can ensure that your rights and interests are protected. Usually, people believe attorneys can only solve problems by going to trial and presenting cases to a judge or jury. And in some situations, a trial is in fact the only way to resolve a conflict. In a majority of situations, however, there are other ways attorneys can help their clients solve their problems that do not involve a courtroom trial. The alternative is a process called Alternative Dispute Resolution, or ADR. In recent years, ADR has expanded the ways attorneys help people solve problems and settle disputes. As with any legal problem or issue that you have, it is important to seek a lawyer's advice. Although not involving a trial with a judge or jury, alternative dispute resolution can be a complicated process and usually requires the aid of a lawyer. With an attorney's advice, it will be easier to select which ADR process is right for your problem and how to best achieve your desired results. There are several types of alternative dispute resolution that we will discuss here so that you are familiar with each. They are mediation, arbitration, early neutral evaluation, and mini-trial. One of the most commonly used types of ADR is mediation. The problem-solving process involves both parties and one neutral mediator. Compared to the formal courtroom procedure, the mediator meets with and listens to both sides. Each side is allowed to offer creative solutions to the problem. The mediator then helps the parties communicate so the parties can attempt to find agreeable and creative solutions. Arbitration is another commonly used type of ADR. In an arbitration, an independent third person presides over the process. Both sides present their respective arguments and evidence. The arbitrator then decides the best solution for the problem. In many ways, an arbitration is similar to a traditional trial, except the proceedings are less formal. Unless the parties agree beforehand, the arbitration decision is not binding on either party. If the decision is not binding, the arbitration decision may be used in fostering later settlement discussions between the parties. An early neutral evaluation is where both sides select an experienced third party, much like in an arbitration, to listen to both sides and present their arguments and evidence. Then the experienced third party tells each side of the various strengths and weaknesses of their cases. This evaluation usually occurs very early in a lawsuit and can help lead to more effective settlement discussions. The mini-trial method of ADR is most like a real trial, but in this trial, 3 evaluators decide the outcome. Each side picks one evaluator, and the parties agree on the third evaluator. At the end of a less formal and less expensive mini-trial, the 3 evaluators tell each side the main issues facing the parties and attempt to help the parties reach a settlement agreement. There are other ADR methods and variations on these methods to help people solve problems. Indeed, one of the most important qualities of alternative dispute resolution is that the processes can be changed to meet the specific needs of each particular problem. Now that you are familiar with the methods of ADR, you may be wondering if it can be used by you to resolve your problem. Alternative dispute resolution is intended to be a flexible tool used by all types of people with all types of situations. From complex business transactions to personal injury claims, ADR can help people resolve all kinds of problems. In fact, ADR has been so effective in reaching solutions that the Iowa State Legislature has enacted a statute encouraging the courts to make mediation mandatory for most couples seeking a divorce. Alternative dispute resolution can be used at any stage of a conflict. The ADR process is available to help people find solutions. In some situations, parties may try an ADR process at the early stages of litigation, conclude that it was ineffective at that point, and then try another ADR process after more information has been accumulated and shared between the parties. At this point, you may be asking yourself why you would want to use ADR if you are unwilling to agree to anything less than what you are demanding. There are several reasons why ADR is still a useful tool, even when people do not believe that they are willing to consider any type of compromise. In a trial, the only certainty is that not everyone in the courtroom is going to get the result each of them desired. With ADR, the resolution of the problem is strictly within your control and not that of the judge or jury. Indeed, ADR allows you to take part in the decision-making process to find a solution to meet your needs. Plus, with ADR, it is possible that creative solutions will be offered which you and your attorney did not even consider, that meet the needs of each party more effectively than any court decision. Even if you have the best attorney and believe you are correct on the factual and legal issues, it is possible that at the conclusion of a courtroom trial, you will have spent more money on fees, expenses, and costs than you were awarded as damages. With ADR, you may compromise and receive less monetary compensation, but still gain more than if you had received a full judgment, because you are likely to have less invested in the problem-solving process. Although ADR is not the perfect solution for every conflict, it should be considered each time a person has a problem and seeks the advice of an attorney. ADR can save money and time and can sometimes result in better solutions than achieved in the formal litigation process. As was pointed out at the start of this presentation, if you have any questions about your legal issue, and if alternative dispute resolution is for you, the Iowa State Bar Association would encourage you to consult with your attorney so that you can ensure that your rights and interests are protected. We hope this video has provided you with some helpful tips regarding the use of alternative dispute resolution in your legal issue. Thank you.